All right, then I'll take up Citizens for Transparency and Accountability and others versus Western Cass Fire Protection District and others. Mr. Layton, you may proceed when you're ready.
Good morning, and may it please the Court.
Good morning.
The Missouri Sunshine Law is intended to put decision-making by public governmental bodies before the public and to give the public the opportunity to observe, to study, and to participate in that decision-making. It requires notice of public meetings, and then that the meetings remain open so that the workings can be observed except for in the limited circumstances where they can be closed. Here we have a series of violations that were shown by notices, minutes, and defendants' testimony. These are defendants who were trained as board members. They learned the requirements of the Missouri Sunshine Law, but still acted contrary to it.
Can I interrupt for a second?
Yes.
I noticed you referred to them as plural. They're plural instances. How many violations of the Sunshine Law are you alleging occurred?
At some point, I think we counted about 46, but I'm not today. I haven't recently gone back to count.
There's at least 11 dates that you cited.
Yes.
Yes. Let me ask you, aren't those independent claims? I mean, aren't each one of those a different and independent claim with different sets of facts and circumstances that need to be considered?
Well, not only each meeting, but each of the items would be an independent item.
So why isn't this? Why aren't, when you group them all together and you do that repeatedly throughout your briefing, why aren't those claims multifarious? Aren't you required to separate those things out?
Well, they weren't separated.
When you make a claim on appeal.
They weren't separated out by the judge in his decision or by the motion that was filed. The motion
does it have to be for you to make it? If they're independent claims, the rules 8401 require that if they're independent and separate, they're to be separated out. It just seems like you're in most of them. There's several that are you have like the one specific date, but a lot of these claims seem like they're multifarious. You're different sets of evidence and different, and you have to weigh the evidence. We have to look at it and weigh the evidence in each one of these instances, and it just seems like it kind of was a shotgun approach on these.
Well, there's a particular problem that was manifest in a variety of instances. So the error of the circuit court is a single error because, at least the way we read the decision, the circuit court read the statute incorrectly. And that it is that incorrect reading. For example, it's reading, at least according to the briefing in this court, that you can add anything that you want to a meeting agenda. It is that incorrect reading of the law that is where the error was.
But you also make claims regarding and against the weight of the evidence claim throughout your claims, correct?
I will confess that I struggled with how to draft points relied on in this case as much as I ever have on an appeal because of the nature of how this was decided below. And so yes, we put that in as well because it's not entirely clear from the court's order, which simply grants a motion which actually didn't justify everything that the complete dismissal of the case.
Well, you could have fixed that by asking the findings of fact and conclusions of law, and you didn't do that, correct?
We did not do that, but I don't know that that fits at that point in the case. I mean, this is a decision that came at the end of plaintiff's case. It wasn't a decision at the end of a trial. It abruptly ended the trial.
But before the judgment was entered, you could have made that request or before the trial was commenced, correct?
That is, I haven't even gone back to the rule to see if you could do it at that particular point.
Well, Mr. Layton, even if we look at the claims about the adequacy of the agendas, even there, and accepting that, over 11 meetings, there were, the use of the word report, the use of the word work group, the use of the phrase special considerations, they're all different slightly, and different topics were discussed under those headings. But even if we say you can group them, weren't there really three, I think, separate claims? One is agendas that were overly vague or ambiguous. Two is items that were discussed which were wholly absent from agendas. And three, arguably a third category, is agendas agendas which were modified at the commencement of the meeting. Should those three issues have been addressed separately in the briefing, do you believe?
Well, I think they were addressed separately in the brief, although I don't know that I created a set of points relied on that matches that. I mean, I think that's the problem. In each of those instances, our claim was that the statute says that they have to advise the public of the matters to be considered, and the court concluded that, at least the way that it's briefed here, that merely noticing the meeting is sufficient to meet that requirement, and it's not. It can't possibly be sufficient to meet that requirement.
Mr. Layton, can I ask you, and Judge Chapman's referred to, I mean, this was tried. I'm a little mystified, honestly, even with the number of meetings, that this consumed 8 days of trial for plaintiff's case. But be that as it may, but it was tried, and even with a judgment at the close of plaintiff's case in a bench-tried case, it's treated as a finding by the fact finder that the court can make credibility determinations, etc. We also have case law that says when a judgment is against the party bearing the burden of proof, that judgment does not need to be supported by any evidence, because the fact finder can simply disbelieve plaintiff's evidence. Given all of that, how on appeal can we rule in your favor as opposed to saying apparently the fact finder was unpersuaded?
Well, then you have to assume that the fact finder in this case can disbelieve the minutes that are the official record of this public governmental body. And I know of no precedent suggesting that you can do that, because the minutes are the record.
Well, were they admitted by stipulation? Or?
No, they were admitted, they were admitted generally without objection, but they were all admitted.
Right. And the agendas.
And the agendas.
And in your view, separate from the May 28th meeting, which may implicate more facts and may be somewhat more difficult for you on appeal, but as to these notice claims, is it your view that merely the agendas and the content described in the meeting minutes establishes the violations?
In almost every instance, but in addition, we have testimony from the defendants.
Does the intent of the creation of them, for instance, when the agendas isn't there, and it doesn't require knowingly and purposefully a violation? Does that matter? I mean, in other words, you can have the agendas and then what happened, and maybe you can say they're vague, and that's one thing. But if the intention was, we just want to put everybody on notice, and if the court didn't believe your client's testimony, and she did, she had an interest in it, she passed around a petition to dissolve this fire district. So, given all of that, I mean, couldn't the court have just said, I don't think this was intentional or no?
Well, that's not the first question. The first question is whether it was a violation. If there's a violation, then the next question is whether it was knowing and purposeful. That goes to the question of whether there are penalties and attorney's fees assessed. But that intent is not a question that arises in determining whether there was a violation. It may be that I find this hard to believe, that they didn't intend to hide on April and August 3rd what they were going to do to Ms. Van Meegeren, but assuming that you can believe that, that still doesn't mean there wasn't a violation. The violation comes because they take up matters that either are hidden or do not appear in the notice. Or the violation comes by holding a closed meeting, and as to the closed meetings, all our obligation was to show that there was a closed meeting. And then it's their burden to show that the items addressed in that closed meeting were all items that fit within the narrowly defined exceptions to the Sunshine Law. So we met our burden with the agendas and the like. And there was no attempt to respond to that, except in this court just a blanket saying, everything fit within those exceptions. But that's not our burden at that point. There's no dispute, and the record shows, based on the minutes, that the closed meetings were actually held.
And Mr. Layton, Judge Chapman has asked about, purposeful, willful, whatever the terms are in the statute, to support penalties and attorney's fees. Because I understand the court did not, in its judgment or in its brief statements from the bench at the conclusion of plaintiff's case, did not express any particular ground for its ruling other than, I find the plaintiff has failed to satisfy its burden of proof. Could the judgment be explained by the court's determination that there was insufficient evidence that any violations were willful, purposeful?
No.
Because were there separate claims for declaratory judgment that there were violations separate from penalties?
No, I mean, there were claims that there were violations.
Basically, if the court just says judgment for defendant,
right,
could that be explained by a determination there was insufficient, I am unpersuaded that any violations were willful and purposeful? And would that explain the statement, judgment for defendants?
It would not explain the grant of the motion, and I don't believe it would explain the actual statement finding.
Because did you seek relief separate from willful and purposefulness, just a declaration that violations had occurred?
We asked that they be found to have been in violation and that the violations have been found to be not knowing and purposeful.
Right. Well, let me ask you this. It sounds like part of your gripe with this, your complaint, is that the judgment wasn't specific enough. And again, you didn't ask for findings of fact and conclusion of law. That's one thing. But if you're saying that the form, aren't you kind of attacking the form of the judgment? And there was no post-trial motion attacking the form of the judgment, was there?
No, there was not.
A post-trial motion for everything. But if you're attacking the form of the judgment, don't you have to file a post-trial motion?
Well, I think the form of the judgment is the judge said, I'm granting their motion. And I didn't have anything to file afterwards saying I'm rejecting the form of that motion. I mean, that is what he said he was going to do. That is what the judgment actually said.
Aren't you kind of attacking it throughout your argument based on its lack of specificity?
Well, I'm attacking it on the basis that the rationale in the motion was not coextensive with the scope of the case that had been presented. But I don't know that that's a form question.
Okay. Do you have any other questions?
Not right now.
Thank you.
May it please the court.
Certainly.
If I can begin, follow along some of the questioning, Judge Chapman, you started with about the variegated nature of the claims made in this case and whether they're independent and what evidence is required to analyze those. I'm sure the court has looked at the transcript. There were 7 days of trial. There were hundreds of exhibits entered, and the allegations and the minutes that were at issue and the agenda that were at issue were testified to in excruciating and mind-numbing detail over those 7 days. So for anybody on the appellate side of this to say that the facts of those items or those items themselves were not considered by the trial court is just not the case, and I think the legal file...
But Mr. Racine, just to take one example, is there any dispute that under a tentative agenda, and I believe it's August 3rd, that simply said special considerations, that under that heading there was a discussion of hiring litigation counsel or filing a lawsuit to have one of the members of the board removed from the board?
No dispute at all, Your Honor.
Okay, so then the question is, does that satisfy the Sunshine Law?
Well,
to say special considerations and then say, I move that we hire counsel to file suit to remove Judge Hardwick from the court. Is that sufficient? And what does the statute say? To reasonably advise the public of the matters to be addressed.
I believe that is.
So isn't that just a legal question? Even forget about 8 days of testimony. We've got the agenda and we've got the minutes and admissions that this topic was discussed on August 3rd.
I believe so.
And on what basis does that satisfy the Sunshine Law?
Well, I think given the way that, number one, the statute's plain language, and number two, the lack or paucity of any case law in Missouri that would guide a public body in crafting agendas or making that reasonable notice known, you have to look at the circumstances, you have to look at the context, and I think that's what the case law, particularly the Iowa case that we've cited, that I think all parties have cited, including the amici, as being something the court might consider going forward as a guide. But is it reasonably calculated under the circumstances in the context? Here we have a split board. We have a board that's, part of the board is threatening to dissolve, is taking steps to sue the board, and if you are talking about litigation matters, first of all, that does get very close to a closed meeting topic, if it is not a closed meeting topic, but also if you're in discussing litigation against one of the other board members, I'm not, in the context of that, I'm not sure what the reasonable notice is and to whom is that reasonable. So it is a legal question that the court is going to have to address based on the context of that particular.
And what is there some context here that, for example, I understand under reports, things like hiring contractors, a landscaping contractor, or a contractor to conduct an inventory of district equipment, or purchase of uniforms were discussed under the topic reports, as I understand it, and I know there's a welter of individual claims here. What is the basis? I mean, it seems like you can compare the agenda to the matters that were actually addressed at the meeting, and then it becomes a legal issue. Was that notice sufficient? And it says, in a manner reasonably calculated to advise the public of the matters to be considered at the meeting. Isn't it relatively obvious? That is, the statement reports or resolution 9-digit number is not sufficient to advise the public of the matter to be considered at the meeting.
Well, Judge, I think that gets into that question of tentative agenda.
So this is a legal issue now, though.
I think it is, because you have to...
And tentative, in your view, means subject to change for any reason or no reason.
I think in Missouri, currently, I would argue that is the case, yes.
Really, despite the requirement that it be reasonably calculated to advise the public of the matters to be addressed.
I think you have to look at both of those requirements, Judge, yes.
But tentative can be freely altered.
Judge, again, I have to argue my client's position on the date these were alleged. And I think on the date these violations were alleged, that is the case. That tentative means what tentative means, absent some statutory or court guidance as to what tentative means. We have to look to its plain meaning, which is subject to change. Now, going forward...
Is there any indication in the evidence, we didn't know that we needed uniforms and it was an emergency and we couldn't take it up at a later meeting. We didn't know we needed lawn care services and it was an emergency. Is there any evidence of exigent circumstances or mitigating circumstances why the agendas couldn't be more informative to the public?
In this instance, I think there are mitigating circumstances or exigent circumstances. Certainly with regard to the August 28th meeting or 24th meeting, I think that's been briefed and the facts are there.
Or is that, you mean the May 20, is it May 28?
May 28th, I think.
May 20th, sorry. Yeah, obviously, yes. So, and that's been briefed, and
that's the short notice. That was the less than 20.
Right, correct. Which may be factual and may be, the reasonableness of individuals' conduct. But with these other matters, isn't it almost like the sufficiency of the pleading? Is the pleading sufficiently specific to reasonably apprise the defendant of the nature of the claim? Courts resolve those issues every day as a matter of the law.
But to get back to your question, Judge, these were a chairman and a vice chairman that had been elected to their positions in an April election. These violations are alleged to have started in May after they're been on the board for a matter of weeks. Had a seasoned board member who was the treasurer in the form of one of the appellants in this case, who abruptly and without warning resigned her position, leaving the financial matters of the district in disarray. So you have untrained folks who are struggling with their
I understand,
position.
and I realize the May 28th meeting may be a completely different matter because that seems very fact specific. Would the chairman have internet access where he was going on vacation? How soon did bills need to be paid, et cetera, et cetera. And there was testimony about these matters. Putting that claim aside and maybe acknowledging that claim we have to accept, the court was not persuaded by the evidence presented by the plaintiffs, or was persuaded by the explanations offered by the defendants. Putting that to one side, a meeting that says special considerations, and there's a discussion of removing a board member, isn't that a matter of law? Here's the agenda. First of all, just on the face of the agenda, what does special considerations mean? Special considerations of weather? Special considerations of finances? Special considerations of personnel? Or, I mean...
Again, tying my previous answer to the court's line of inquiry here, I think those are the mitigating or exigent circumstances in that you have an inexperienced board trying to comply with the law. Did they use an inartful phrase? I think there was also testimony in the record prior to my involvement. The district had counsel and special considerations it was testified to was suggested by their attorney at the time.
Mr. Racine, and those may be, and the trial court may be fully entitled to find that any violations which occurred were not knowing and purposeful. But even if the court found that, it found violations, but then found they are not knowing and purposeful, you have inexperienced board members, they relied on erroneous advice or whatever it may be, still, wouldn't the plaintiffs on their petition be entitled to some relief on count one, at least a declaration that there were violations? Didn't they seek relief beyond a finding of knowing and purposeful?
Judge, I'm glad you're asking that because it was one of the points I wanted to bring up. I pulled the what was denoted the second amended petition. It was really the first amended petition. And I looked at the prayer for relief in count one. And it says, plaintiffs asked this court to order the district to comply with the Missouri Sunshine Law. Well, that sounds like an injunctive type request. To declare, declaratory judgment sounds injunctive to me, invalid any action taken in its May 28th, 2022 meeting and any other meeting that violated the law. Find that the violations were knowing and purposeful, and impose penalties and award costs and attorney's fees to plaintiffs pursuant to the Sunshine Law. So two of the things asked for, I know prayer for relief is a prayer for relief, but given how this petition was drafted, it's really what we have to go on, given the 200 and some paragraphs that were thrown against the wall on this thing. But at least two of the things that they asked the court to do were injunctive in nature, a declaration and an order. And that goes back to an issue that came up in the appellant's response brief about the plaintiff's own unclean hands in this matter. I think there was injunctive relief requested that invokes the unclean hand doctrine against them. So from a procedural and from our defense standpoint that was raised in our brief, I do want to point that out to the court. But yes, so when the court's asking me, are they entitled to some kind of relief on what they asked for? Judge Wagner certainly didn't think that any of these rose to the level of violations.
And do you agree, and maybe that's do you agree, Judge Wagner found that these agendas, as they were drafted and the discussion of items beyond the agendas, etc., did not violate the Sunshine Law?
I believe that. Yes.
As a legal matter.
As a legal matter.
Right.
He talked about burden of proof.
Right.
Which to me connotes a legal decision.
Right.
Or a decision based on a legal issue.
Right. Which is this use of tentative.
Well, for that part of the argument.
Right.
I think there were other arguments that were made, and certainly the court can review that in the motion itself,
yeah.
The motion for judgment.
Well, one thing, by the way, on the May 28th meeting, I noticed your motion, and again on appeal, refers to summary judgment affidavits of certain of the defendant board members. And this case was truncated at the close of plaintiff's case. Were those affidavits in evidence in trial?
Yes, but they were in evidence in the court's record. I don't know.
Right, but summary judgment affidavits are not trial evidence. You can't justify a jury verdict based on affidavits that you submitted 8 months earlier in support of a summary judgment motion.
So both of those respondents, John Webb and Marty Hardman, who gave those affidavits in the summary judgment proceeding, were both called as adverse witnesses by the plaintiffs in the case.
But then why refer to their affidavits? Why not refer to their trial testimony? Did they testify in trial in plaintiff's case to what was in their summary judgment affidavits?
Yes.
about no internet access in Colorado and,
Yes.
et cetera, et cetera?
They did.
Okay.
I'm done with my time. I will withdraw if there's no other questions.
Thank you.
Our point is to the May 28th meeting is that even if you assume all of the facts, the way that they were set out, whether in the briefs or by the defendants in their testimony, is still, as a matter of law, is insufficient to show that holding the meeting later or deciding or noticing it earlier was impossible or impractical. This group knew 10 days before that meeting that the treasurer had resigned. That's clear, undisputed, and that the chair was going to leave on vacation. Assuming that one person leaving on vacation could ever make holding a meeting impossible and impractical.
Well, let me ask you about that.
Yes.
In your briefing, do you acknowledge any evidence that would support the idea that it was impossible or impractical? I mean, there was testimony of these people that said, we had to get this thing going. We were behind on our bills. There were all these problems. You don't acknowledge that anywhere in your briefing.
Because even if all that is true, that was true and they knew it on May 18th. That doesn't explain why they waited until the night of May 27th to set a meeting the next morning.
But don't you think that if we're to weigh the evidence that should have been mentioned at least in your briefing?
I don't think that it's relevant. It's not relevant because the question is, could they have noticed the meeting earlier? And that doesn't affect whether they could have noticed the meeting earlier. It doesn't get there. I just have to mention, there was a lot of trial because this was not the only part of the case. My clients were trying to get access to information. They were being deprived of information. They felt like they were being railroaded by other members of the board, and the case was much broader than it is on appeal. As to the notice, we don't have to have precedent. We know what the statute says. They went to training. They were told what the statute says. The statute says you have to give notice that is enough to tell the public what matters are going to be considered. And that's the point of view you have to look at it from. Did the public know, as to special considerations or these other things, what matters were going to be considered? Sure, things can come up during meetings, but the proper thing to do, if something comes up that's not on the agenda, is say, okay, thank you, we'll put that at our next meeting, unless it's an emergency. And look at the Iowa case, and there's a subsequent Iowa case that's discussed by the Missouri Press Association amicus that points out it's an emergency. But here there was no emergency in that respect. Notice could have been given earlier, and notice in each of these instances, each of these meetings could have told the public what was going to be discussed. But instead, they had it as a policy to add things to the agenda and take up things during the meeting that the public knew nothing about. Those are violations of the Sunshine Law, and the Circuit Court should not have ruled otherwise.
Thank you, Mr. Layton.
Thank you.
I'll show the case submitted, and we'll be in recess until 11:30.
All right. Thank you.